I now call upon the Honourable Attorney General to move his motion. You have the floor, sir.
Thank you, Mr. Speaker. Sir, Mr. Speaker, sir, pursuant to Standing Order 51, I move that the Criminal Procedure Amendment Bill 2021 be considered by Parliament without delay, that the bill must pass to one stage in a single sitting of Parliament, the bill must not be referred to Standing Committee or other committee of Parliament, and that the bill must be debated and voted upon by Parliament on Thursday, 11 February 2021, but that 1 hour be given to debate the bill with the right of reply given to me as a member moving this motion. Thank you, sir.
Is there a seconder?
Mr. Speaker, sir, I beg to second the motion.
I now call on the Honourable Attorney General to speak to his motion. You have the floor, sir.
Thank you, Mr. Speaker, sir. Mr. Speaker, sir, the Criminal Procedure Act was in fact put in place in 2009, where we completely repealed the Criminal Procedure Code of 1944. There were a number of archaic provisions that related and was in relation to the Penal Code, which we inherited British India, Queensland, and came to Fiji, which is now called the Crimes Act. One of the archaic provisions that still remain, Mr. Speaker, sir, and is becoming quite problematic now, is the issue of what we call lay assessors. And Mr. Speaker, sir, just as a matter of interest, the Criminal Procedure Ordinance of 1875, the criminal justice system was very heavily influenced by what we then was ethnic considerations. So, if you're a European, you had your case only tried exclusively by a European jury. But if you're any other ethnic group, then the cases were tried by lay assessors, but who also were Europeans. The legal theory being that when Europeans as lay assessors decided on cases concerning non-Europeans, they may have a particular bias, so therefore the judges could overrule the decision of the assessors. That was a philosophy that actually continued until the 1950s, when people of other ethnic groups were then included in the list of assessors. And in 1961, they got rid of all what we call the all-European jury system. So since then, we've kind of been left languishing with this particular assessor system, which essentially means, Mr. Speaker, so in practical terms, if a group of assessors finds somebody guilty, the judge can overturn them. And on the other hand, for example, if the assessors find a particular ruling or say the person is not guilty, the judge may simply go along with them. Now, this has led to a number of inconsistencies. And one of the other issues we've also discovered, Mr. Speaker, so is that there's only a handful of assessors that are currently being used. There's only about 30, 40 people who actually act now what I call professional assessors. And they're well known to the registry clerks, they're well known to the lawyers. But more so, Mr. Speaker, so what we are concerned about in particular is that given we have a small group of people, they're very subject to economic, peer and political pressure and influence, and in particular the level of sensitization. When we talk about sexual offences and gender-related offences, Mr. Speaker, sir, and recently we've seen some cases in respect of that. When you come in, a lot of people are coming from a very patriarchal-based society, we are getting a lot of inconsistencies in the verdicts, for want of a better word, by the assessors. So in some cases, we've recently seen that where very similar facts, very similar evidence, assessors find not guilty. In other cases, they find them guilty. And similarly, the judges, whether it's maybe the mood of the day, they may go along with the assessor, or maybe they don't actually get influenced by the assessors, they go against the assessors. So you cannot have a criminal justice system, in particular when you're trying to address issues such as gender issues, that will have a dual system. We need to have a consistency. You either have the decisions of all the assessors always adhered to, like a jury system, or you actually don't have the assessors, where the assessors' decisions can sometimes be followed and other times cannot be followed. Interestingly enough, Fiji and Vanuatu are the only countries in the Pacific that actually has the system. Everybody else has moved along. So, Mr. Speaker, sir, we are seeing a lot of this, in particular some of the prejudices coming through, in sexual assault and rape cases, etc. And in particular, for example, when you're now getting sophisticated crimes, usage of technology, etc., the ability for the assessors to perhaps comprehend these matters and come up with a ruling is very, very limited from that perspective. So, Mr. Speaker, sir, this amendment seeks to remove the assessor system and have the judges, like in many other jurisdictions in the world, have the judges actually make the decision themselves. Thank you, Mr. Speaker, sir.
I thank the Honourable Attorney General for his motion. Honourable members, the floor is now open for debate on the motion. At the end of the debate, we will have the right of reply from the mover. Is there anyone wishing to take the floor? Being no one wishing to take the floor, Honourable Attorney General, you have the floor.
I have nothing further to add, sir. Thank you.
Honourable members, the Parliament will now vote. The question is pursuant to Standing Order 51. A, that the Criminal Procedure Amendment Bill 2021 be considered by Parliament without delay. B, that the bill must pass through one stage at a single sitting of Parliament. C, that the bill must not be referred to a standing committee or other committee of Parliament. And D, that the bill must be debated and voted upon by Parliament on Thursday, 11th February 2021. But that 1 hour be given to debate the bill with the right of reply given to the Honourable Attorney General as the member moving this motion. Does any member oppose the motion? As no member opposes, the motion is agreed to unanimously. Secretary General.